Welcome to our quizzer, focused on the 2019 amendments to the 1989 revised rules on evidence. This is part 2 of 15 educational tool which is designed to deepen your understanding of these amendments, which play a critical role in legal proceedings. The rules on evidence are fundamental in determining what material can be considered by the court to ensure fair and effective adjudication. By engaging with this quizzer, you will gain a clearer insight into various types of evidence, such as object, documentary, and secondary evidence, as well as the principles governing their admissibility. This knowledge is essential not only for legal professionals, but also for students and enthusiasts who wish to understand the intricacies of legal processes. The quizzer will cover key sections from Rule 130 of the Rules on Admissibility, including object, real evidence, documentary evidence, original document rule, secondary evidence, parole evidence rule, and interpretation of documents.
Q1. What is defined as object evidence under Rule 130, Section 1? Object evidence includes any items addressed to the senses of the court and relevant to the fact in issue, as per Section 1, Rule 130. Q2. What are the forms of documentary evidence as described in Section 2? Documentary evidence can be writings, recordings, photographs, or any material containing letters, words, sounds, etc., as outlined in Section 2, Rule 130. Q3. Under what conditions can a duplicate document be admitted as evidence according to Section 4, C? A duplicate is admissible unless there's a question on the authenticity of the original, or if it's unjust or inequitable to admit the duplicate. As per Section 4, C, Rule 130. Q4. What are the exceptions to producing the original document as per Section 3? Exceptions include cases where the original is lost, destroyed, not produced without bad faith, or held by the opposing party who fails to produce it, as detailed in Section 3, Rule 130. Q5. How can one prove the contents of a document when the original is unavailable according to Section 5? The contents can be proved by a copy, a recital in an authentic document, or by witness testimony, following the rules in Section 5, Rule 130. Q6. What is required from the adverse party when the original document is in their control, as per Section 6? The adverse party must produce the document after reasonable notice and proof of its existence, as specified in Section 6, Rule 130. Q7. How are voluminous documents handled in court as per Section 7? They can be presented in summaries, charts, or calculations, with originals available for examination, according to Section 7, Rule 130. Q8. How can the contents of a public record be proved when the original is a public document, according to Section 8? The contents may be proved by a certified copy issued by the public officer in custody, as per Section 8, Rule 130.
Q9. Is a party bound to offer a document as evidence after calling for its production and inspecting it, according to Section 9? No, a party is not obliged to offer it as evidence, as stated in Section 9, Rule 130. Q10. What can a party introduce to challenge the terms of a written agreement under the Parole Evidence Rule, Section 10? A party can present evidence of an intrinsic ambiguity, mistake, or additional terms agreed upon, under the conditions in Section 10, Rule 130. Q11. How should a document be interpreted if there are conflicting provisions, as stated in Section 12? The construction should give effect to all provisions, if possible, as per Section 12, Rule 130. Q12. What takes precedence between a general and a particular provision in a document, according to Section 13? The particular provision prevails over the general if they are inconsistent, as specified in Section 13, Rule 130. Q13. How can the circumstances under which a document was made affect its interpretation, according to Section 14? The circumstances can be shown to place the judge in the position of those who executed the document, as per Section 14, Rule 130. As per Section 14, Rule 130. Key takeaways. The 2019 amendments to the 1989 revised rules on evidence provide a comprehensive framework for the admissibility and handling of various types of evidence in court. Understanding these rules ensures that legal practitioners and students can effectively prepare and present evidence. Essential for successful legal outcomes. This quizzer serves as a valuable tool to revisit and reinforce crucial concepts from Rule 130 concerning evidence rules, enhancing both academic and practical legal skills.